it's, it's hard to put the salt in my beer. That's not good.
But Sean,
Back on my knees.
hey, the month is almost over. Time is moving fast. How many days before Christmas? Well, I say it every year, but this year I'm going to do it. I'm going to get my Christmas cards early, send them to my mom early.
I say that about Halloween candy. I want to get my Halloween candy early, and I never do.
Well, with mom, what ends up happening is I get her Christmas cards, and then I end up having to overnight them. Because my mom says, if you're giving somebody a birthday card or Christmas card, you need to give it to them early so that they can sit it out. So, for example, since my birthday is at the beginning of November, my mom starts sending me my birthday cards. Yes. So I'm like, okay. And then if she sends them and they don't arrive till the 20th, she's always like, I'm sorry for being late. I'm like, I celebrate the entire month. It's okay.
Right. Yes. I never knew your middle name was Stephen.
Scott.
It's Stephen.
Scott.
Why did you change it to Scott? I thought it was Stephen.
It was named after Scott Carpenter.
Oh, I'll be nice.
The astronaut.
Wait a second. But your last name is Kimler.
Kim,
Why didn't you change it to Carpenter?
Spanish to English, so help you God. Thank you. And are you Jaime Paredes Gonzalez? And Mr. Gonzalez was here and pled guilty to aggravated assault. I've received a copy of the pre-sentence report. The agreement was for a cap of 10 years in prison. Has everyone had an opportunity to review the report?
Yes, sir. Yes, Your Honor.
Are there any corrections or additions?
Well, Your Honor, it appears that he's denying the offense, so I don't know how the court wants to proceed. He says a plea of guilty and not a plea of no contest. So.
Mr. Gonzalez, in the report, it shows that you said that you did not do what they charged you with. So when you were in court before, I asked you if you were pleading guilty freely and voluntarily. And I asked you if you did what they charged you with. And you answered yes. Did you do what they charged you with or not?
I think he's denied stabbing, which is the predicate for making it the felony.
So why don't y'all go visit just for a minute, Mr. Kimler,
Yes, ma'am.
please, and let me know if he.
I think the guy, as according to Mr. Nichols, the man was stabbed. He got me with the stab on
Several ones went to the hospital.
So there's no question on there. So it's said on the trial lawyer. He's denying stabbing.
So if you, Mr. Gonzalez, if you deny that you stabbed him, then I'm going to set your case for trial. I'm not going to accept a plea agreement. And a jury can decide whether or not they believe you stabbed him.
He says we did hit each other, but the knives were close.
So if you didn't stab him, then we let a jury decide. If you think you did stab him, then we go forward today.
She was very familiar with Atlanta. She was focused on the research. She was probation only gets over this.
Well, you may not, even if you say you stabbed him today, I might give you prison. I can give you 10 years in prison. So you're not necessarily going to get probation. And if you don't, and hang on, and if you don't accept responsibility, you're definitely not going to have me consider probation.
Yo no sé si le pegué con lo corté o no, no sé.
I just don't
No, ya sangre
remember.
no nada.
I just don't remember that I
Yo no
stabbed
tuve
him
de atrás.
and I didn't see no gun. The other guy got me from behind. I just watched.
All right, so at this time, I'm going to reject the plea agreement and set the case on the trial docket. Hang on, let her tell him what I'm saying.
Guilty? That was his response.
You have to, you can't just say I'm guilty. You have to say, I stabbed him.
No, solamente.
That's what you're charged with.
Yo sí le pegué con la navaja, pero no, pero te vas a agarrar.
I did hit him with a knife, but it was closed.
All right, you can go back with the bailiff. We're gonna go to trial.
We'll make it perfect.
Do you have like a,
Just stop right there on the couch.
I believe you were busy with that dockets, but, Judge, when I gave my CLE about the hemp bill, it is now legal for stores to sell marijuana. And marijuana is for sale all over the city of Beaumont.
he tested positive for marijuana.
Right, which is illegal in the state of Texas.
Marijuana is now legal in the
Yes.
state of Texas, 100%. No, it's not, sir.
Well, it is
No,
not
it's not.
if it meets a certain threshold.
Okay, that's going to be your burden because he's tested positive for THC, and we're not going to open the door for everybody to show up high because they're saying, "Oh, I got this. This has got to be legal marijuana."
Well, but there is legal THC in the city of Beaumont. That's all. I'm just trying to point that out. The conditions of bond states that he cannot break the law, but there's not a condition that states he's not allowed to use legal substances. And I've spoken with him. He did use legal marijuana. It's available at the store. And that's.
I'm not going to have a hearing on that, but I will have a hearing on it. But his bond is revoked right now for testing positive. We're going to stand by this. I know you want to make a big stand on that because of your presentation, but marijuana, THC is not across the board legal. It's not. It's not. And you can't just say, well, we're going to test positive here and I got to get out of jail free card. And I'm going to drive around town. I'm going to leave here, get in an accident, kill a bunch of people, and then test positive. And then they're going to say, what idiot judge let you loose after you had tested positive here in court? That's it. But if you want to write your name and say, I'm responsible if he goes out and hits some people when he is testing positive here on the test, and I'll accept responsibility for all of that. Go ahead, but I don't think that you're going to do that. But somebody's got to be responsible. And the fact of the matter is that I know that there is certain THC that's out there that is has been deemed not illegal.
Right.
But and I also know that because I helped on this bill, and that is medical use of tetrahydrocannabinol,
Right.
Cannabis, and which is not the sativa L, but
What is?
I helped on that. So I'm involved in that, and I know I'm sensitive about people who do need treatment, but that has to be administered through medical expertise. You can't go into somewhere off the street and say, okay, this has got to be legal. I don't think so. I don't think so. I don't think so. You don't know what's in there. You really don't.
We're not judging off the street, not if you're buying it from the corner, but it's available.
Where's he getting it?
From the store. There's lots of stores in, I mean, there's 100 stores in Beaumont that
Okay.
sell marijuana.
I'm
over
not
the
going to,
counter.
that is not a get out of jail free card. We can have a hearing on it, fine,
Understand.
and we'll litigate it. If that's what you want to do, great. That'll be done, but we're not going to set loopholes for people to be running around saying, I'm going to the store and getting it out of the store. And so it must be good stuff.
It's all right. I've tried it.
Well, good for you. Well, I hope that if you're not, I hope you can, well, I mean, the point of the matter is if somebody goes out and kills some people in a car wreck and it tests positive, nobody's going to be laughing about it.
100%.
There's nothing funny, especially from yesterday when we had decapitation of poor victims, decapitated in a car wreck because the guy was intoxicated.
Right.
Whether it's alcohol or other substances that can foul up your abilities to act responsibly. People, it's not funny with what we have to deal with. There's nobody saw those pictures and think there's anything comical about someone who can get into a 4,000-pound missile and drive around high.
Right. I agree with you 100%, Judge. The only point I was trying to make first was that he failed a urine test, not a blood test. Obviously, in a car wreck situation, it would need to be in his blood to be causing intoxication, not in his urine. But my concern, only, Judge, is just to point out the notice issue. The standard bond conditions that are given to people when they leave the jail, I believe it says don't break the law. It says have an interlocutor ear to DWI and don't go around the victim. The problem here, not just for him, but a general problem maybe the county needs to address is that it does not state anywhere do not become intoxicated. And it doesn't state do not use legally intoxicating substances. In fact, it doesn't even say don't drink alcohol. So in this scenario, he was using a legal substance and there was no notice for him to not do so in the bond conditions.
Did you drive up here today? Don't look at him. Did you drive your car up here? Did you drive your car? Yes.
But he's not intoxicated right now. He did fail a blood test. It's a urine test. Urine goes back for a month. If he used marijuana
All right, we
last
can
month,
talk about this at another time.
I understand. I just
Judge,
right now.
maybe, is there a time for a quick docket before trial next week where court could take this up? They would have an opportunity to get whatever it is they think they need to get to put in front
I
of you.
can set it for any time. I can set it for any time. I don't have to do a quick docket anytime.
Well, I think that's what we're calling them now. That's why I'm referring.
What's a quick docket?
It's the ones before trial each week. That's what we're calling them now.
You only give us 30 minutes.
No.
You see what I'm saying, though.
That was my coordinator's idea, which I don't disagree with. But we can't complete it in 15 minutes anyway. But yeah, I'm sorry. We're going to stand by our test and y'all can appeal me. we're gonna stand by our test that he is testing for an illegal substance and his bond is revoked and doubled. What's his bond right now, please? Not looking him to gamble out of here after I've got a test. That's blood on my hands. I'm not gonna do that.
Weird.
And the test that we use is supposed to be is presumed to be a valid test.
Don't disagree with the test, just disagree that the substance found is illegal.
5,000, 5,000, and 100,000.
Okay. The bond is, your bonds on the 2 5,000s are doubled to 10,000 each. And yeah, do you have a drug patch?
He's not have a drug.
You're gonna have a drug patch from here on. I'm gonna treat you like everybody else does, like everybody else is treated who tests positive for substance.
I don't understand.
He'll talk to you.
Yeah, he's not 100% English, so.
Yeah, he'll talk to you about it, but here, my telling that if you're on bond, why flirt with trouble? That's just a foolish. Don't get near that stuff. Even if you think it might be legal, if it's going to be testing positive, why go through this? But I'm going to stand by the tests, but you can beat the rap, but not the ride. I think is a terrible statement because I don't want to take the ride.
No.
Even though it might. But that's just right now. This is still being. They're still navigating, trying to figure out how to sort all this stuff out. And until they do, why would you even flirt with the trouble on bond? I mean, it's just not a wise thing to do. It's like playing Russian roulette. Anyway, that's what we're going to do. I'm doubling those 2 5,000s to 10,000. So you're gonna have to post another bond in each of those two cases. That's is a $10,000 amount. Anyway, that's what we're gonna do. All right, on Mr. Hernandez. Okay, and here on you come in, Mr. Ord, and get a resetting. Go.
Okay, so the people versus Carlos, is it Gasca?
Yes, Your Honor.
All right, state your name, please, sir.
Carlos Gasca, Your Honor.
All right, you are before the court on the charge of operation of a motor vehicle without security. That is a misdemeanor punishable by up to 90 days, $500 fine plus court costs, no less than a $200 fine. You understand that, sir?
Yes, Your Honor.
All right. First question I have for you is, do you wish to be represented by an attorney?
No,
Okay, what are you gonna do then?
I would like to show proof of insurance that I have with me that I did not have with me in the vehicle.
So how are you gonna do that?
And show, pull it up on the screen.
Really? And then what do you want me to do with that?
I would like to have where could I send the proof of insurance for the charge that I had for the ticket? With no insurance.
Who are you gonna send it to?
I would like to know where I'm able to send it to.
Oh, you can send it anywhere, but the only place it's gonna probably make a difference is to send it to the prosecutor's office.
Towards you, I meant.
Are you sure you want to represent yourself? I'll wait.
Yeah, I would like to have an attorney, please.
Okay, there we go. This
Yeah,
is a public defense. Probably a wise move, young man.
Yeah.
Silvana
Thank you.
Reed, Assistant Public Defender, with and on behalf of Mr. Gasa, we would waive any further reading of the charges, stand mute, and request a pretrial date.
Defendant having waived from a reading, standing mute, court will enter not guilty plea. Pretrial in this matter will be adjourned to June 7th, 2023. 9 a.m. as your Zoom invite indicates. I'll set the defendant's bond at a $5,000 personal recognizance bond under standard conditions, including no assaultive behavior or use of weapons. There's also to be no use of alcohol, recreational marijuana, or any illegal drug. Do you understand all of that, young man?
Yes, Your Honor.
Let me give you a phone number so you can call. Okay. Area
Okay.
code 734.
734.
Who's that writing for you?
My mother.
Yeah, I figured as much. I knew that, but I just thought I'd ask. All right. Area code 734.
Yes, sir.
222.
Yes, sir.
6970.
Thank you.
All right. You're welcome. When you call them, make sure to give them a valid phone number and a valid email address so they can contact you. Okay.
Okay. Thank you, Your Honor.
All right. And you made a good choice with the attorney because you had 90 good reasons why you needed one. All right.
Yes. Thank you.
Thank you.
Have
Have
a
a
good
great day.
You too.
Court calls the case. People versus Justin Goldowski.
Carmen Dadush on behalf of the people.
This is an arraignment.
Okay, so I think, oh wait, let me let Ms. Ritter come back on screen.
Oh, sorry, Judge.
Okay, so I think I stopped short. I said the court is satisfied, and then I stopped short of saying I will accept the guilty plea. And so having had extensive conversation in the breakout room, the court will accept the guilty plea. I will set the matter for sentencing July the 20th. Mr. Nichols, you have a right to be sentenced in person or on Zoom. Which one do you prefer?
Zoom, Your Honor.
Court sets the matter on Zoom at 9 a.m. prior to sentencing. You must submit to a pre-sentence investigation, a substance abuse evaluation, and a mental health evaluation. So, Mr. Flanagan, make sure that the probation can you highlight that or something on your referral that I added the mental health evaluation? I want him to do it before he comes back for sentencing.
Yes.
All right. And then I would also like a copy, whether it's through probation or whether it's through one of the lawyers here, I would like a copy of his circuit court probation order.
Okay.
So if I could have that at the time of sentencing, that would be great for me. Then I can look at what they ordered, and then I can look at what you all are asking me to do, and see if I want to add anything and blase split.
So, Judge, would the court like for the people to try to get a copy of that since it was a global resolution?
Yeah, that will probably work. You could probably get it. But yeah, just I want to see that, and then also I do want to put you on alert. So it sounded to me like he might have been ordered to do some classes or something through the circuit court. I just need you all to understand that I have confidence in me and you all and the people that we send our people to. And I don't know what the circuit court time frame is, but if he wants these probations to run concurrently and not have to duplicate efforts, whatever the circuit court is telling him to do, he might want to wait. I mean, I know he probably has a lawyer on the felony, but I can almost guarantee you I'm sending him to Mr. Rice.
Okay.
So whatever he's doing with circuit court or whatever, and that would be maybe for that self realization class, or if he's already taken parenting classes. I don't think Mr. Rice does parenting classes, and I know that I send a lot of people to Mr. Rice, so it might be a little waiting period. But
May I interject for a minute, Your Honor?
You may not, but I am going to share what I shared in the breakout room, and you could discuss it with your lawyer. I'm real disturbed by the whole thing. I'm real disturbed. I'm so disturbed by the whole thing. As soon as somebody said the age of the complaining witness, I got real disturbed. And therefore I'm disturbed. And so I wanted to get some further information so that I can see if Ms. Stevenson needed to talk to you to see if you wanted to withdraw your plea. So when they first said that to me, I was ready to put somebody in jail. But I'm open to not. I'm open to the probation. I'm open. But as long as we're going to address the issues as to what would cause an individual to strike a 2-year-old in the face with a wooden object, if we're not going to get to the root of that, I'm not interested. And I would only be interested in penalty in jail. So if we're going to get to the root of that, if we're going to address the root of that, then I'm interested in probation, because I'm all about changing lives, changing thoughts, changing ideas. But what I detest, and so I'm gonna just let you know, Mr. Nichols, as soon as they say there's a 2-year-old involved, I said, what in the world would cause a person? And then I said, it must be something, mental health issue going on. Some mental health issue, some drug issue, some anger issue, because it's not parenting. Now, I know they're going to send him to parenting classes, but hitting a 2-year-old in the face, that has nothing to do with how to parent. That has to do with anger, mental health, drugs, or something else. And we're going to get to the root of it in here so that none of the grandkids ever have to be afraid of the granddaddy. Because granddaddy's supposed to be passing out candy and letting them swim and taking them outside in the park. The kid's supposed to be happy to go see the grandparents and then don't want to go back home because the grandparents are supposed to be spoiling the kids. And grandparents supposed to be, I already got a whole bunch of stuff that I plan to do with my grandkids that I don't even have, that ain't even on the way yet, to spoil them and then send them back to their parents and let the parents parent them. But I can't even imagine a scenario that I would pick up a wooden object and hit my 2-year-old grandchild in the face. That's deplorable. So whatever you wanted to say to me, say it to your lawyer. But we're going to do probation, but it's not going to be, So I said I wouldn't put you in jail, at least at first. I'm gonna give an opportunity for you to comply with some probation, but I need some more background information from probation so that I can fashion the probation in such a way that when we're finished with Judge Bryant's probation, because I don't know what'll happen when he finishes with circuit court probation. I don't know. I don't know if the judges even ever see the people again when they're on circuit court probation. I don't know. But when he finishes with Judge Bryant's probation, he's going to have a changed attitude. He's going to have a change philosophy. He's going to, I hope, know that it's never, ever appropriate, ever in the whole wide world, ever, to hit a 2-year-old in the face with anything. And he's going to have a changed idea. And then he's not going to turn his face away from me. That's like being at the podium and turning your whole body to the side to denote that I don't care about what you're saying. And when you do that, then I decide I don't care about this either. And let's just do the alternative to probation. So probation is the alternative to jail. Jail is the alternative to probation. So if you turn your head from me again while I'm talking for an extended period of time, like you just did, it might be a good idea for you to come in person. So what we're not going to do in here is pretend like this is not a serious matter. What we're not going to do in here is pretend like just because they made some resolution on a felony case and he pled to another misdemeanor after hitting a child in the face, what we're not going to do in here is pretend like that ain't a serious matter. It's pretend like the little child is not traumatized. It's pretend like, oh, this should just be a little slap on the wrist and go. No, we're going to do some stuff in here that I can at least say we tried to make sure that no other child had to feel scared of their granddaddy getting slapped in the face by the granddaddy. Okay, anything further?
No, thank you, Judge.
On behalf of Mr. Nichols, Your Honor, understanding that the court is loading Eve up. I know that Mr. Nichols
I don't want him to start early either.
Well,
because I don't know exactly what I'm gonna do, Ms. Stevenson. I don't know what I'm gonna have him do.
Okay. I need him to get on a waiting list or something now.
No, he might not be able to. He can get on whatever waiting list he want to get on, but until I see the pre-sentence investigation report and until I see the circuit court probation, you know, what they've ordered him to do, I don't know what I'm going to order him to do. I really do not know what I'm going to order him to do. But he's going to probably have 2 years to do it. I don't know. He's on probation with circuit court for 2 years. So, but I'm just saying. I'm not saying I'm going to put him on probation for 2 years. I'm not saying that. You know, of course, he has 2 years. But I mean, I'm just not. I can't tell you what he's going to do. So
I understand that, Your Honor. I can absolutely appreciate that. Secondly, I don't know that this has ever been addressed by the court, but Mr. Nichols has, I believe with the permission of the court, relocated to the state of Ohio. And I don't know if I ever put that on the record, but we are requesting permission that he remain in the state of, that he be able to continue to live in the state of Ohio.
As long as he don't blade his face for me again.
Okay, Mr. Nichols, we want to absolutely just face
his
the
face
camera.
from me again. He gonna come in person every time we come to court, and that's gonna mean he gonna have to drive, fly, or do whatever he can do to get to Detroit. But as long as I don't require him to come in person, as long as he don't turn his body from the court again, because that's what that's equivalent to, standing at the podium and turning to the side. That's what that's equivalent to.
Understood, Your Honor. So other than those two issues, I do not have anything further at this time, and we thank the court.
All right, then it appears that we are all set until July the 20th at 9 o'clock on Zoom. And probation is going to contact you by telephone. I think I may have already said this, but probation is going to contact you by telephone. If they cannot reach you, they are going to leave you a message and mail you a letter directing you to contact them so that they can prepare a proper pre-sentence investigation on the date of your sentence. Make sure you respond to their phone call, and you probably really need to make sure you respond to the phone call, because if you live in Ohio, I don't know when the mail might get to you. All right, we're all set. Have a great day and stay safe.
Thank you very much.
You're welcome. And that looks like that's everyone that appeared today. So we're going to be all set. I'm going to stop the live stream.
Go Tigers.
Yes. And you know, people are complaining about the refereeing, and there was some crying. There should be no crying in basketball. You know, I feel it. As someone who was a forward, there's no crying. But if you realize that referees are calling the game tightly, you know what you do? You change the way you play. You don't complain about it, because everybody was getting fouls called. LSU, as we've known to do, the bench played fabulously.
What's the referee in question from Louisiana, Judge?
All right, so you know what? I want to gag our heart against Mr. Mauer.
My dad was happy.
Yeah, I know. I was thinking about him. I was like, yay. And everybody was texting me. They were like, oh my gosh, oh my gosh. And of course, me, even if you're up by 100 points and it's 2 minutes left in the game, I'm like, don't text me. There's still 2 minutes left. But yeah, it was awesome. All right, we're back on 2022 CR 3725B, State of Texas versus Jacqueline Wallace. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
John Coons for Ms. Wallace.
All right. So we are, and are you Ms. Wallace? All right, we're back. The reason why we're back is because the court was making a determination on whether or not to give you deferred adjudication, because the court heard some things from both parties that gave the court pause. Is there anything else either party would like to say to the court before I make my announcement?
Judge, just, I know you have a memory like a steel trap, so I don't need to follow up too much, but if you'll recall, there were two complainants on this case, one of which was my client's ex-boyfriend, and you were discussing with my client the passion and the rage that must have gone into her thought process, basically, in terms of why this happened. The female complainant is the one that wrote a letter to my client while she was in jail. She has forgiven my client. It sounds like she wants to move on with her life and doesn't seem particularly opposed, if at all, to my client getting the deferred. Interestingly, the complainant who is opposed is my client's ex-boyfriend, the one that was cheating on her, the one that my client was supporting, the one that never.
All right, everyone, please whisper.
The one that never had a job, the one that has been seeking medical bills for these nebulous medical expenses that he can't provide any proof for. It's my understanding he's homeless now because he hasn't found another sugar mama, so to speak. So based upon what you've heard, the facts coming from both complainants, I think that Jacqueline is an appropriate person to get deferred. She's been in custody now for about 15 months. And she's been away from all of her children this time. It's been very difficult for her and her family. She has most certainly learned her lesson, Judge. She'll comply with any terms and conditions that the court deems appropriate. And so we would request that you place her on deferred.
All right, and I'll note that the state, you're silent, is that correct?
You're silent, Your Honor.
All right. Any issues you which to speak to, which are what you would deem questionable facts that are being presented by Ms. Wallace from last hearing, or no?
Your Honor, I believe we clarified in the PSI, there was a statement from her where she said that there was no one else involved. I did clarify that on questioning Ms. Wallace, and she did affirm again that Juan Rosmana was there and was not going to participate with her. So I don't have any other issues.
All right, so Ms. Wallace, I'm going to give you a choice. Normally I can't give people choices, but the state is silent. I can sentence you to 5 years prison. Because of the nature of the case, you would have to do half the time before you're eligible for parole, or either I can give you 9 years deferred adjudication. If at any time your deferred adjudication, if you were revoked, the court would be able to sentence you up to life in prison. So what would you prefer?
Deferred.
All right, and counsel, Ms. Claudia is saying that her medical expenses were $2,000. Any objections to that?
No.
And then I think Renee Patina is saying his expenses were $1,500.
We will object to that.
All right, state, do you have any medical?
We do not, Your Honor.
Okay. All right, this is what the court will do. Court will sentence you to 9 years deferred adjudication. There's a $1,500 fine that will be probated.
Thank you, Judge.
Taking consideration 2022 CR 3726A. There's an affirmative finding of a deadly weapon. 200 hours of community service restitution, 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to want intensive parenting classes. I know you've already completed it with CPS, but I'm going to want those done again because there are decisions that should be made, and you should be thinking about that when you're taking these actions. There's to be no contact with Margie Claudio, Claudio, or Renee Patino. There's to be restitution of $2,000 to Margie Claudio, anger management, CPS compliance if applicable. Probation, I'm going to want the UA hotline until further notice with testing at least once a week, proof of employment within 30 days of release. There's to be no employment as a home health care provider with minors. I'm going to want supportive, counsel, they're recommended intensive outpatient treatment. So I'm going to go with their recommendation.
Okay.
Intensive outpatient treatment with probation. And there's to be sober meetings. And I'm going to want 90 sober meetings in 90 days. I'm going to want field visits 1 time per month until further notice. Probation, if you want to count the field visit as reporting, you can. And please tell them when they go do the field visits to make sure that the home is appropriate for children. Probation, is there anything else she needs? Is there anything you need from the court in order to be successful? All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargaining agreement, because I'm going to want field visits 1 time per month until further notice. Probation, if you want to count the field visit as reporting, you can. And please tell them when they go do the field visits to make sure that the home is appropriate for children. Probation, is there anything else she needs? Is there anything you need from the court in order to be successful? All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing. When you have children, your children 100% depend on you. I tell people this 1,000 times. When you have underage children, you can't just have them and put them off at Travis Park and say good luck to you. So your children depend on you. And this time that you've been in the Bexar County Jail, your children have been without you. Children do not like, and they do not understand when parents say they're going to be somewhere and they're not. The last thing you should do is let some other relationship take precedence over your children. And that's why you're here, because you let that relationship take priority over your children. And here's the other thing. When a man or somebody is doing you wrong in a relationship, don't go attacking somebody else who owes you zero loyalty, and don't go attacking anybody. What you do is you say, you know what? Either I'm going to accept that this person is treating me poorly and cheating on me, or either I'm going to cut them loose. And then you move on. You understand? Yes, sir. All right. Thank you. You have a dismissal?
He's getting better.
Okay.
Thank you very much, Judge. Thank you
All right,
for your consideration.
You're welcome. You're welcome.
Mr. Wallace is in custody. And now I have 2 cases here on Marcus Anthony Hamilton. Is that you, sir?
Yes, sir.
All right. On 23 CR 233. Yes. This indictment alleges that on or about January 15th, 2023, as does the second case, 23 CR 1175. It looks like two charges grew out of one event. That here in 233, you committed a third-degree felony of unlawful possession of a firearm by a felon. And the statements that you were convicted of robbery in 2010 out of the 252nd District Court of Jefferson County. You were also convicted in 2010 for a different robbery out of that court. So if all of this was proven true because they've alleged the other robbery, you're looking at second-degree felony, which is up to 20 years in prison if convicted. And here in 1175, it is alleged that you committed a second-degree felony of illegal possession of methamphetamine. And the two robbery convictions in 2010 are used here in paragraphs 2 and 3. And if found true, that would enhance you to first-degree felony punishment. So you would be looking at up to life imprisonment for that one. And y'all want to try, right?
At this moment, I was trying to.
He said it. We got to make a decision here. What do you want to do? Let me see. Let's see. How long you've been? You were indicted August 16th. I guess you were arrested. Have you been in custody since this event?
Yes, sir.
We're going 10 months. So yeah.
Well,
No, he was. This says January.
I got out on accusation and they rearrested me in I think April or something like that.
Yeah, these were committed on or about January 15th.
Yes.
So I mean that makes 10 months, right? He's been in custody.
Well, he got released, Judge, in January after 2 or 3 days, then was rearrested on the indictments.
The indictment came about in May, so I guess you got arrested again after May 2nd when this was indicted. Well, there was one indictment on May 3rd, and then another indictment in August 16th.
Yeah, I had already been arrested on the basis of the seal.
Okay.
Yeah, the 233 was a firearm case. That was indicted.
You've had several months to think about it. We'll set them. You want them set for trial? This is announcement day. It's trial or an agreement. That's the options.
You don't want to accept the plea bargain agreement, is that correct?
Set it for trial. It will be set for trial. Mr. Grove is a very competent lawyer. He can represent you. It'd probably get to trial quicker if you agree to release him since he's a public defender and I can get somebody off the trial docket wheel.
Okay, that would be cool.
But that's your choice. If that's what you want, the next person off the trial docket will be appointed today. This will be set for trial and we will try the first-degree felony first.
Judge, he also would request the court to reconsider the bond.
What's his bonds now? What has changed in the bond situation? Nothing. The bond.
He has been in custody the whole time and
yeah, what's changed?
I don't believe anything has changed.
Then the bonds are the same. What are they? Well, y'all can tell me anything new.
That's no firearm case, $25,000.
Yeah, one case was from like May and the other one was not indicted until August.
We were waiting on lab results.
Yeah.
The possession of controlled substance is $50,000.
You still living in, is your home still in Houston?
Yes, sir.
Oxford Park?
Yes, sir.
Is that where you would go if you were released?
Yes, sir.
If you do post a bond, you must have a drug patch as a condition of bond along with those bonds.
Yes, sir.
We'll set it for trial. That is all. Kevin?
Yes, sir.
You're up, kid.
Okay, I have Mr. McCain.
Mr. McCain. So you knew about the gas cap thing?
Well, yes, because
That
I've had
happened
that
to you?
red light over the years several times, and it's always that gas.
How did you know that? Did
I
somebody, did you
guess
figure that out?
I looked in the manual. McCain.
McCain, Jamal McCain.
It actually says it in the manual that the red light.
And not mine, but it says something about,
It's like check engine or something, but it's really sometimes it's just that.
well, they said if the check engine light just is on, if it's not blinking, call immediately and get some advice. But you can still drive it. Just don't drive it hard. But if it's blinking, pull over.
See, I didn't know that.
Or that is fatal to the old car. All right. Are you Jamal R. McCain?
Yes, sir.
You're here with your attorney, Ms. Mantellini. And what are we doing today on these? There's 3 cases. Tell me which ones.
Yes, sir. He has these 3 cases and we're placing them on the trial document.
Okay. All right.
I think
So-
2 or 3rd degrees and 1 is the 1st-degree murder.
Yeah. 23795 and 23796 similarly alleged that on or about April 18, 2023 in Jefferson County, Texas, you committed the 3rd degree felony in 795 of tampering or fabricating physical evidence with the intent to impair it. You also have 1, 2, 3 prior convictions out of this court and the 252nd, which are in sequence, which if all was proven true, you're an habitual felon. You're looking at 25 to life imprisonment. And looks like those are all going to be the same, similar punishment ranges. In the other cases where you, in 796, where it is alleged that you unlawfully possessed a firearm by a felon. And then the murder case is on or about June 6th of 2023. It is alleged you committed the 1st degree felonies of murder, and also prior convictions are alleged. If all true, you're looking at, again, no less than 25 years in prison, up to life imprisonment. And you want this on the trial docket. It'll be set for trial. And Ms. Mantellini is certainly able to help you. She's a very competent lady. It would probably get to trial quicker if you agreed to release her. The next person on the trial docket wheel would be appointed, but that's your call. That's the way the indigent commission works. Is your call. Do you want to get it quicker to trial?
No.
Okay, then that would. The best way would be to release her, and the next person on the trial docket wheel will be appointed today, and let's get ready for trial.
And also, Your Honor, he is asking if you would reconsider his bond.
What's changed?
He happens to be aware that the co-defendant's bond was reduced.
What's
and
changed for him?
Nothing that I'm aware of, except that he is hoping that you would reduce his to.
By goodwill? Whoever set the bond in the first place, I don't know who it was, but I'm sure there's nothing for me to suggest that whatever they did was wrong.
No, Your Honor.
Or unreasonable. But if there aren't any new events to talk about, then the bond would stay the same.
And it would distinguish, Your Honor, you'll probably recall that was the one involving the text where they had text and it led up to the murder play-by-play with Mr. Morian was the attorney on it. But that the bond was reduced to $500,000 in that case, but she was not the shooter. Mr. McCain is alleged to be the shooter, so it's distinguishable in that, Your Honor, that he's actually alleged to be.
It won't be reduced. If you do post a bond, you'll be at home confinement. You must have a GPS device attached to you if you post a bond. Do you understand? Anything else? That is all. Okay, and Ricketts, I already signed
Yes,
that,
sir.
Kevin, so that's it for you, right?
Yes, sir.
Okay, here are these three. Oh, Langston,
Ready?
come on up. Carl Solomon, I guess, and
Yes, sir.
what are we doing on Carl there?
I think we got something.
You think? There he is. This is yours,
Yes,
this
sir.
case? Okay, 20-34667 is called Carl Sampson Solomon III. Is that you? And Mr. Adams is here representing you. Does the, well, what are we doing? Is there an agreement?
Yeah, I think we got a plan on him, Judge.
Yeah,
It's to,
it's not showing up on anything.
No.
No, you're. Oh, okay, all right. What?
It was gonna be to release him for 60 days. All his violations are technical violations, as I understand them, and even the underlying offense. And I think, Judge, if you won't be talking to the prosecutor, if we can come back and Daniel.
Well, Your Honor, I believe it.
Look, failing to report.
Yes, sir.
Be AWOL. If you're not going to the supervision, you're not being supervised. And I'm pretty strong about that. That didn't get a second or third chance with me.
Yes,
You told the report. He was, and it's not one time, twice. I've got 1, 2, 3, 4, 5, 6, 7 months. 6 months. What's all that about? That should have never happened. What was there something more important on your menu other than here coming and reporting? If you don't report, you're not on probation. That's we don't need probation office. If you don't report, they can all go home. We can save a lot of money, but they're there for a purpose, to help you. But if you don't want to help yourself, no, you just, I mean, if it's 1 or 2, but 6 times, no, sorry. It's not, I don't go for that. But what do you want to do next? It does look like these are, but of all the things that, or you want to call them technical, it's not really technical. Failing to report is everything. If you're not reporting, you're not on probation.
I was reporting when I went in sick and the champ turning around.
All right, we'll have a hearing on it and I'll make the decision. I'll set it for a hearing. When can y'all be ready for that?
Next Monday.
Okay, I don't know. What? This Monday. Monday week? Okay. Is that a trial week?
It is.
Okay. Yeah, let's do it then. Mercedes Wells. We'll see y'all back then. Yes, sir. What are we doing, Mercedes Wells?
That's a fix.
How many? Or please. I mean, how many you do?
Well, it's 3 new cases and everything else is MTRPs. So I did the paperwork on the 3 new cases, but on the MTRP.
I mean, there's 15 cases.
Right.
So how many are we doing to do? I mean, how many are y'all doing? How many y'all write up? 15?
No.
We've already written up those when she played the first time.
Right, she's already, well, I already.
I don't, look, y'all, I don't remember. Get over here. There we go.
No. Right. She's gonna.
I don't know which ones, or it doesn't say, and I can't remember exactly. She's familiar, but I don't remember. But what here? What is she pleading to, so I can check these things out?
Judge, she is pleading true to the allegations and the MTRPs.
What are those numbers? Because I only have one MTRP announcement. That's all. I don't know what the others are.
That would
So
be
give me the numbers.
everything except for these cause numbers right here, Judge, are MTRPs. 23 DCCR 0818.
Hold on. That's, yeah, 816, 817, 818.
Those are not MTRPs. Those are new offenses.
Everything else is
MTRPs.
well,
MTRPs.
okay, of different cases.
Yes, sir.
Yes.
So y'all have 12 things written up?
No,
There's no agreement, on those, Judge, other than we're agreeing not to stack.
right, we plead open to you, Judge. That's why that's why we're gonna do it. She's
Okay,
gonna plead
what did
truthfully.
we do on the other three?
Other three,
There's, it's showing 816, 817, 818. What do we, were those revoked already?
no.
Those are new
That's
cases.
brand new.
Okay, those happened after she committed these?
Yes, sir. While she was on probation in the other cases. So what we're needing, Judge, is for the court to review those three cause numbers and accept the pleas in those, and then to make determinations on the pleas of true.
What are they? State jail felony?
Yes, sir.
Is everything a state jail felony?
No, sir. There are two cases that are enhanced. There's an engaging, which is cause number 21-384047. And then there is a UUMV third degree felony.
I have, looks like pleas on, plea agreements on 816, 817, 818.
That's the
Yes.
new case.
And then the others, there are no plea agreements. She's just pleading open.
Right. Wait.
And the underlying basis for those MTRPs is the new offenses that she is pleading here to.
Oh, okay. Okay.
So ultimately, I think the court will want to updated PSI with the new offenses, and then you can make your determination, Judge.
How long has she been on probation?
Judge, she was on probation for about a month before she committed new offenses.
Oh, no, I don't need an update.
I wouldn't have anything to say.
Okay, so let's go with that. Should we take the last three first?
I think you should, Judge.
This could take care of 50% of my docket. All right, here we go. 816, 817, 818. And these 12 on here are in the queue. Pick up those in a minute, right?
Yes, sir.
Because those, the allegations are these three events.
Yes, sir. And Judge, for purposes of these three cases, we are agreeing not to proceed on the enhancement paragraphs.
Okay. Just paragraph 1.
Paragraph 3 of each. Yeah, paragraph 1 and 2 of each need to be included.
Which makes it a state jail.
Yes, sir.
And actually, you only need 2 events.
Yes, sir.
Right?
Yes, sir.
I'm counting here. Correct me if I'm wrong. Are these all these cases that she's on probation for?
Judge, I believe that
No, because
those
it can't be because
right.
There's Harris County, Brazoria County.
Judge, I believe that those
But a bunch of
cases
Jefferson
are
counties.
those cases mirror her previous offenses that she pleaded true to.
Oh, it's in the, no, it's, yeah.
Until you get to
So all of
December
those
of
that-
22.
So paragraph 2 includes these 12 that she's on probation for, where there's a motion to revoke probation, right? Okay. Okay. Okay, and what was she on? 205? Is that what she was on those?
Judge, I believe, so that's where there's a little bit of a difference in her probations,
Is
because.
there some third degree?
Yes, sir. There were 2 third degrees
Okay.
and she was on 10 years probation in those. And then the rest were all 205.
But it was 8/10.
Yes, sir.
May I see her pre-sentence report, please, first, before we go into that? Thank you. I've done this for a long time, and I think Ms. Wells is the most prolific thief that I've presided over in cases in my 16 years, the most prolific.
I will note, Judge, that in those PSIs, the gist of most of the comments from the detectives and the victims are all that they firmly believe she will not quit stealing and needs to go to prison.
And this states by one of the detectives, she understands the importance of restitution, paying this loss back, but she will steal to pay the restitution.
And ultimately, Judge, I think, her conduct while on probation, proves that to be accurate. She essentially went to retail locations outside of Beaumont thinking that would somehow, make it so she could get away with it.
And Judge, just so you can remember, when we did these pleas, she was 8-9 months pregnant on the day that we did the plea. She just recently had their child. And while I'm not trying to justify this, she does have 7 other children. And what they've said is partially true. I think one of the reasons for the death is that to pay the probation and pay. I mean, if you look at what I'm just saying, just give me out.
Yes, I'm anxious to hear how this ends.
Well, what I'm saying is that to my understanding, what the main item that was taken is clothes. And with 8 kids herself, and it's not like too many places are gonna hire you with all those theft convictions. She was trying to make ends meet. And it's not like she was going, to my understanding, and talking to her, where she was, doing anything violent, anything like that. She was taking to make ends meet. And she does have 8 kids.
She does not take care of those kids, Judge.
It's not doing it. Take care of all my kids. I have custody of all 8 of my kids.
What I'm sure he's probably saying, it doesn't matter how you're taking care of them when you're in prison or in jail. Somebody's got to be taking care of the children, not you. And is this? I'm looking at Victoria's Secret's clothes. Is that what this is?
Yes, sir. She stole over 30.
The kids are getting Victoria's Secret outfits.
The detective suspected she was selling them on Facebook, but we could never prove it.
Well, but those aren't. There are other places. If you look, I'm on the Salvation Army board. You can go to the Salvation Army and we'll clothe people. You don't have to steal. People know that, but we don't have a lot of Victoria's Secret stuff in our repertoire of things. Okay, I see. I think I see where we. Does the defendant waive formal readings of these three cases here?
Yes.
23C or 816, 817, 818? Can we proceed in summary?
Yes.
In That's all I've got on my screen. You don't know my password.
You're on, you're good.
Can we proceed in summary?
Yes, sir.
He needs to look at the tablet. My tablet? Yes.
In summary, these similarly allege state jail felonies of theft and with a second paragraph of 2 or more prior theft convictions, which paragraphs 1 and 2 constitute, since it looks as though the first paragraph of these thefts allege theft of an amount less than $2,500, which would otherwise have been a misdemeanor. So paragraphs 1 in 816 alleges on or about March 8th of 2023 in Jefferson County, Texas, you committed theft. And these were all from large national clothing stores here in Beaumont. That in 817 paragraphs 1 and 2 allege that on or about March 7th, 2023, you committed theft. And then in 23 CR 818, paragraph 1 and 2 constitute a state jail felony of theft in paragraph 1. And then 2 or more prior thefts in paragraph 2. Those are similar in each of these three indictments. And are the prior convictions used to enhance in these, or are these just state jail felonies?
Right, Judge. We are agreeing not to proceed on the convictions that would enhance punishment in these three cases.
Okay, so in each of these cases, these are filed as third-degree felonies.
Judge, if convicted, the punishment range would be if the third-degree felony range because of the enhancements. However, we are agreeing not to proceed.
Well, this is third degree, so it's state jail felony.
Right. State jail.
But you've checked off third degree felony. You did the third degree papers. You did the.
I see what you're saying, Judge.
You didn't do the state jail felony. You didn't do state jail felony papers. You did. See, those are third degree felonies check, not state. I know, but then we're gonna have to write in the state jail, I guess.
Just on the little, I'll write it with a blank little thing is scratched it off and I'll write the state jail felony.
Sigh. I hear a big sigh.
It's just one of those days. Either one of those weeks.
I'm putting a state jail felony up at the top. Okay.
Thanks, Jimmy.
And also, it needs to be in here. no less than 180 days up to 2 years in the state jail, and a fine up to $10,000. That's the punishment range for each of these 3 cases. Do you understand?
Yes, sir.
And then apparently y'all have made a deal
Well, no stacking
for what?
and for,
Oh, there is no deal?
no, it isn't, well, no.
It says paragraphs 1, only proceed on 1 and 2, 0 restitution.
Right, Judge,
There's no
there's
amount.
no
It's for
terms
me to
beyond that.
decide
Yes,
within that range. Is that right?
yes, sir.
Okay. The essentially the
deal is
crux of the agreement is she's not looking at up to 10 years in prison for these cases.
Correct, Judge.
Right, and those, and not stacking.
In fact, it would.
But you
No,
decide.
yeah, it's not alleged otherwise. It would be 10 years on that. Not, y'all didn't do.
Correct, Judge.
So you're looking at, again, not less than 180 days, no more than 2 years confinement in the state jail. And there's no fine, but you were subject to a fine of up to $10,000. You understand?
Yes, sir.
And in each of these 3 cases, agreements have been reached where you would be subject to the state jail felony punishment, and it would be up for me to decide. Is that your understanding?
Yes, sir.
If I follow these agreements, you have no right of appeal on your cases. Do you understand?
Yes, sir.
How do you plead to each of these thefts alleged in 816, 817, 818? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And those prior thefts, those numerous prior thefts alleged, I don't even know. They're well, 15 prior thefts convictions as alleged in paragraph 2. Are those allegations all true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those voluntarily?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign those documents in each case?
Yes, sir.
Did you understand them, discuss them with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 in each case in 23 CR 816, 817, and 818 are presented and without objection.
No objections.
They will be made a part of the record in each case. In each of these matters, the states that you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you, and you've read that you are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your attorney. All of this is true. It states, so help you God. In each case. State's Exhibit 1 is part of the record in each case. Stand by. I've got some writing I gotta do. I'm pleading truth to enhancement. Okay, we're gonna just take that. That's irrelevant, really. State Yeah. These are all state jail felonies, right?
Yes,
These
sir.
three.
Yes, sir.
We've got restitution in this one, right? In 1817, y'all got restitution written.
Yes, sir. There should be two cases where there's restitution.
Restitution is in the amount of $2,748.47 to the complainant in this case, correct?
Yes, sir. Dillard's.
Okay, these are the documents. A17. One more. Did I show Ms. Wells States Exhibit 1 in each case already?
You hadn't yet, Judge.
I show you what's marked as States Exhibit 1. Did you sign those documents? Did you understand them, discuss them with your attorney? Are the contents all true and correct?
Yes, sir.
States Exhibit 1 is tendered into evidence in each case without objection.
Objection.
Admitted. Among other things, this states you are mentally competent to enter your pleas, which are freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read them. You are guilty of the crimes charged and any lesser included offenses. You're giving up your rights to a jury trial and the right to the apparent confrontation, cross-examination of witnesses in each case. Totally satisfied with the representation by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
And 818 has restitution, by the way, in the amount of $309.73 to it's like Burlington Coke Factory in Plano.
Yes, sir.
I think those are the only two, though.
Yes, sir.
Now, how do you plead to paragraphs 1 and 2 in each of these cases, guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily and because you are guilty? And all those prior convictions in paragraph 2, I think 15 of them, are in each case similarly alleged. Are those true and correct as they are alleged? And are you pleading true and correct to those voluntarily?
Yes, sir.
All right. Should I make findings on these cases or should I go to the other
Judge,
motions to revoke as well?
I suggest the motions to revoke.
Okay, these will be held in suspense.
Judge, I believe each motion to revoke in those cause numbers, count 1 of the motion should be one of the offenses that she just pled true to.
Right. Having my hands. In numerical sequence. Well, 12 cases where Mercedes Dion Wells is on probation. And these are all state jail. No, they're not all state jail felonies.
Judge, this is a reminder of which ones are which. That's the front of the PSI.
21-38407 will start off as a motion to, and by the way, does the defendant waive formal readings of the motions to revoke probation in these 12 cases?
Yes.
Can we proceed in summary?
Yes, sir.
On 21-38407, in summary, this states that on December 12th, probated for 10 years, engaging in organized criminal activity. Is that true?
Yes, she was placed on probation, Judge.
Allegation 1 states that you committed the offense of theft on or about March 8th, 2023 in Jefferson County, Texas. Is that true of 23 CR as well as? No.
Just say 16.
16. Is that true or untrue, ma'am?
True.
Are you pleading true to that voluntarily and because it is true?
Yes, sir.
You understand by pleading true, voluntarily and knowingly, that is enough to grant this motion to revoke probation. Your probations can be revoked. You can be sentenced, found guilty if it's deferred or unadjudicated probation, revoked as well if it's regular probation, and you can be sentenced up to the full range of punishment that you were assessed originally for. Knowing that, you insist on pleading true.
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. And you've been sworn in already today, I guess, huh? When you entered these pleas, and do you solemnly swear or affirm that all the statements you're making today that you've made up to now and the ones that you're making from here forth in this hearing are all true and correct, so help you God?
Yes, sir.
All right, lower your hands. Okay. Again, are you pleading true to this allegation, knowing that that is, and this applies to each of these, so I don't have to go over it again. Every time you plead to an allegation, or each of these pleas are true, and are they alleging the same thing?
Yes, sir. Every motion to revoke is the same. However,
Right.
there are two that are third degrees and the rest are.
Allegation one is going to be used in each of these as the basis on these motions, since you're charged with 5 different things, at least on this, but number one is the same. That is, you committed a theft March 8th, 2023 in Jefferson County, Texas, which is what you have pleaded guilty to in cause number 23 CR 816. And anyway, in 38407, if your probation is revoked, you are looking at no less than 2 nor more than 8 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. In 22-39896, this is another case where this states in summary that on December 12th, 2022, in this court, you were sentenced to 8 years in prison, probated for 10 years for unauthorized use of a motor vehicle. And allegation number 1 is that March 8th, 2023 Jefferson County theft that you pleaded guilty to and pleaded true to as well in another motion to revoke probation. And I'm going to add true to this one, because you're saying in each of these cases you are pleading true to that allegation voluntarily, knowingly, intelligently, and because it is true.
Yes.
And in this case, if your probation is revoked, you were looking at no less than 2 nor more than 8 years confinement in prison, correct?
Yes.
Knowing that, you insist on pleading true. I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. By the way, all these sentences are going to be running concurrently, correct?
That is our agreement, Judge.
All right.
Or the MTRPs are.
Is that your understanding? Everything, no, it's not stacked on top of each other. 22-39897. This alleges that on December 12th, 2022, you were sentenced to 2 years in the state jail and probated for 5 years for theft of property. Is that true?
Yes, sir.
And allegation 1 is the same allegation that you pleaded guilty to here, committing theft on or about March 8th, that you've already pleaded guilty in the indictment and pleading true to allegation 1 in all of these motions to revoke probation. And is your plea of true here voluntarily, knowingly, intelligently, and because it is true?
Yes, sir.
And in this case, your probation, you were looking at no less than 180 days up to 2 years in the state jail. Knowing all of that, do you insist on pleading true in this case?
Yes, sir.
Fine, you're pleading true voluntarily. You understand and appreciate the consequences. So please, on December 12th, 2022, it's to state jail, probated for 5 years for theft of property. And paragraph 1 is that March 8th theft that you've been pleading true to, and is this true as well?
Yes, sir.
And you also pleaded guilty on this day to theft in 40324. And do you understand by pleading true voluntarily, knowingly, intelligently, if your probation is revoked, you are looking at no less than 180 days up to 2 years in the state jail? Knowing that, you insist on pleading true today? Fine, you're pleading true voluntarily. You understand and appreciate the consequences of pleading true there. and 22-40325. This also states that on December 12th, 2022, you were sentenced to 2 years in the state jail, probated for 5 years for theft. And paragraph 1 of this motion to revoke probation alleges that March 8th, 2023 theft you pleaded guilty to already, and it has been that I find is enough to find you guilty beyond a reasonable doubt. And are you pleading true to this allegation in this case voluntarily, knowingly, intelligently, and because it is true? Knowing that, you insist on pleading true, knowing that you were looking, if revoked, no less than 180 days up to 2 years in the state jail. I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. And in 22-40326, this is another December 12th, 2022 theft conviction, whereby you were sentenced to 2 years in the state jail, probated for 5 years. And allegation 1 in the motion here alleges that March 8th, 2023 Jefferson County theft. And you're pleading true to that as well in this case, correct?
Yes, sir.
Knowing that you were looking at if the consequences here of being revoked and looking at no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. 22-40327 is another state jail felony conviction where on December 12th, 2022, you were sentenced to 2 years in the state jail, probated for 5 years. And the March 8th theft we've been talking about in 2023 in Jefferson County, Texas is paragraph allegation 1 of this motion to revoke probation. Are you pleading true to that in this case?
Yes, sir.
Understanding the consequences that your probation can be revoked and you can be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true? Fine, you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. 22-40328 also is a motion to revoke probation where it is alleging that on December 12th, 2022, you were sentenced to 2 years in the state jail, probated for 5 years. And allegation number 1 in this motion alleges the March 8th, 2023 theft out of Jefferson County, Texas, that you pleaded guilty to and true to in the other motions to revoke probation earlier. Is this also true in this case?
Yes, sir.
And are you pleading true voluntarily, knowingly, intelligently, understanding the consequences that your probation can be revoked and you can be sentenced no less than 180 days up to 2 years in the state jail?
Yes, sir.
22-40329 also is a December 12th, 2022 conviction, and it alleges a state jail conviction of a sentence of 2 years in the state jail, probated for 5 years. And allegation number 1 in this motion alleges the March 8th, 2023 theft conviction. Is that true as all the others we've been talking about in this hearing? And are you pleading true knowingly, intelligently, and because the allegation is true? You understand the consequences here. This is a state jail felony. You're looking at, if convicted, if your probation is revoked, you could be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
And in 22-40330, this also alleges that you on December 12th, 2022, were sentenced to 2 years in the state jail, probated for 5 years for theft. And allegation number 1 in this motion to revoke probation here states that you committed theft on or about March 8th, 2023, Jefferson County, Texas. The same allegation you've been pleading true to and guilty to in the earlier cases in this hearing. Do you understand the consequences that your probation can be revoked and you can be sentenced to no less than 180 days up to 2 years in the state jail?
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
Fine, you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. 22-40331 also states that on December 12th, 2022, you were sentenced to 2 years in the state jail, probated for 5 years for theft. And paragraph 1 of this motion to revoke probation here alleges that March 8th, 2023 theft from Jefferson County, Texas, that you have pleaded guilty and true to in these other cases. Is this also true for this case?
Yes, sir.
You understand the consequences? You're looking at revocation and no less than 180 days up to 2 years in the state jail as a consequence. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. Finally, 22-40332 also alleges on December 12th, 2022, you were sentenced to 2 years in the state jail, probated for 5 years for theft. And this motion to revoke probation alleges an allegation number 1, the March 8th, 2023 theft of clothing that you've been pleading guilty and true to in these hearings. And is this allegation in number 1 also true in this case?
Yes, sir.
Do you understand the consequences if you plead knowingly, intelligently, and voluntarily that your probation can be revoked and you can be sentenced to no less than 180 days in the and up to 2 years in the state jail? And is your plea then knowingly, voluntarily, and intelligently made in all of these cases? Now, find you in each of these motions to revoke probation. Case 12, we pleaded true to that same allegation. Number 1, voluntarily, knowingly, intelligently, and because those were all true and correct. Anything else to add?
No, sir.
I'm going to and in these cases, just again to summarize, the 2 prior third-degree felonies that you were sentenced to 8 years in prison, probated for 10 years, that you were placed on that you were placed on probation for. Okay, I've got that wrong. We've got really we have 3 different situations here. Everybody follow me here. Ms. Wells on 23 CR 816, 817, and 818 has pleaded guilty to 3 cases which constitute state jail felonies of theft. Correct. She is currently on probation in these 12 cases. 2 of the probations, 38407 and 39896, are third-degree felonies for which she was. Is that right?
Right, that's correct.
She was sentenced to 8 years in prison, probated for 10 years.
And just to clarify too, Judge, those are state jails punished as third degrees.
Those have to be correct.
And she had pled true previously to the enhancements.
Those are state jail felonies for which she was convicted of the state jail, but punished as a third degree or second degree.
In as a third degree.
Third degree because of prior convictions.
And
So
then the,
he was looking at no less than 2, no more than 10 years confinement in prison. As the sentencing range, I sentenced her to 8 years in prison, but probated those 2 cases.
yes, sir.
And then now we have these and state jail felonies for which she was on probation for and has pleaded true to violating her probation. So she's looking at probation sentence of state jail felonies in 39897, 40324, 40325, 40326, 40327, 40328, 40329, 40330, 40331, and 40332.
Yes, sir. And to add to that, Judge, as well, the only agreements that we have as far as what cases are to run concurrently are the cases where motions to revoke have been filed. We are agreeing that whatever sentence the court decides to impose, that they should be run concurrently on that. We have no agreements about the 3 unagreed pleas that she has pled guilty to today.
Okay, and those are you're talking about?
Yes, sir.
16, 17, and 18.
Yes, sir.
And those are all state jail felonies.
Yes, sir.
But okay, so what do y'all? This y'all's turn now.
You wanna, we're asking that you give her a sentence on these cases. We're asking for maybe 4 years on these 2 cases where she has to engage in a criminal activity and unlawful use to run concurrent with all the rest of her case, her state jail felony cases. And I'll let her speak to that. Ms. Wills, you understand that you were placed on probation in December of 2022, is that right? Yes. And these offenses occurred, the 3 new cases we got, I think it was in March of 2023, right?
Yes.
So one of the questions that's going to be raised is what happened between the December plea and then when you get the cases in March, all right?
Yes.
So when you took the plea in December of 2022, do you remember when you got out of jail?
December 18th.
About December 18th?
Yes, sir.
And when you got out of jail, what was your financial situation at that point?
Okay, nothing.
You had nothing? All right. And I know you were pregnant when we took this plea. Had you had the baby, or were you still pregnant?
I was still pregnant.
So when you got out of jail and judge let you out of jail and put you on probation in these cases, where did you go?
Went home to my mother.
Okay, so you went home to your mother, you're pregnant while you with your mom. Are you able to work at that point?
I'm sorry.
All right. And so you basically living with your mom, is that right?
Yes, sir.
So when you had the baby, when was the baby born?
February the 13th.
So basically you get out of jail on the 18th. And I think at that point you were what, about 8 months, 9 months pregnant?
Yes, sir.
So you were fully showing at this point, right?
Yes, sir.
February you had a baby, right?
Yes, sir.
So now when you had this baby in February the 19th, you said?
The 13th.
The 13th. You hadn't been working, you're living with your mom. What's your financial situation now? Okay. Did you have any place to go? All right. As far as your ability to work, have you tried to get any kind of work?
I was seeking, but I had to wait 6 weeks until I had a job.
Okay, so you had to wait 6 weeks till you had the job, all right? So if you look at that, that's gonna get us closer to around this March 8th, because you get now, the baby is born, I think, February the 13th, all right? And you still had to wait 6 weeks, so you still couldn't work, right? Now, if you're living with your mom, was there, you have 8 kids, right?
Yes, sir.
Was there any issues with money or finances?
No, I don't care. So the same. Most of my child, increased.
Okay, so what was going on with you that caused you to have to commit these offenses?
Operation, fees, feeding for kids. When Joseph used to try to send me Jordan's research to try to help me. Yeah, pay for it, which is
Right, so the long and short of it is that ankle monitor was costing you when you got out of jail, how much? A month?
And
And then with the fees, so you tell me, I'm leaving now. You're leaving now? So you tell me what kind of fees you were looking at when you had the baby in February, you got this case in March. What kind of fees were you looking at? So the long and short of it is the state suggested that when you went to Victoria's Secret, that you was selling some of these clothes that you got from Victoria's Secret. Remember I told the judge, I think he was trying to make ends meet. Yes. It wasn't necessarily, were you trying to make ends meet?
Yes, sir.
So in trying to make ends meet, you regret the decision you made. Are you asking, I know I don't want to use the word leniency, but are you asking the court to take into consideration that the month before you picked up this case, the baby was born, right?
Yes, sir.
So that baby would need clothing, infamil or whatever, to go with a baby, right?
Yes, sir.
And in having that baby plus 7 other kids, was it tough on them?
Yes, sir.
So are you asking the court not to stack any of these cases, but to put you on, since all these cases concurrent with the new case, and to have a little mercy on you?
Yes, sir.
All right. Is there anything you want to say in your own words that I have not covered that you think might be something that the judge wants to know?
I know what I do wasn't right. But sometimes it's just hard. And with me, I can't help playing to help like talking about it. Because you do things that wind up in the consequences.
Right. And at the end of the day, you're not a violent person. You don't have it. From what I'm read about you, learned about you, and you're not gonna harm anybody, anything like that. So if the judge did 4 years, let's say, on these 2 cases, and then run concurrent all the rest of the other cases, would you be able to start with a new life?
Yes, sir.
And turn all these issues around?
Yes, sir.
Now, what was your relationship with Ms. Joseph while you was on probation? I know it's not a long time, but at least y'all got to know each other.
Yes, she was trying to help me.
Right. And what services did she offer to you?
George, she used to see me, George, because I was pregnant and then I had to wait and see her afterwards. But she used to help me with your researches and just a lot of ins and out stuff.
So you're not one of these people that's coming to the judge bad mouthing the probation department.
No.
What you saying is you thanking her for what she did.
That has never worked in the past.
Right.
Even if that would be true, they might as well shoot themselves in the foot. That's never worked for a defendant before in 16 years.
So basically, you thanking Ms. Joseph for all of the work that she did, right? In trying to get you employment. But one of the big hurdles for you with employment, at least from talking to you, is with all these theft cases, it's kind of hard to get somebody to hire you.
Yes, sir.
Right.
I think y'all have made your point. Yeah.
Right. So are you asking basically to
something.
4 years or something similar to that. And then once you do your time, you just come back and start a new life.
Yes, sir.
Stay.
Isn't it true that when you were arrested in 2023 of this year, or March of this year, that you had promethazine in a baby bottle in your car?
It was nothing in the baby bottle, sir.
And is it also true that you had $2,000 cash in your center console?
Yes, I did have cash, sir.
Where'd that come from?
My mother carried my kids from income tax and she gave me the money from carrying my kids for income tax.
Well, you wouldn't have needed to steal things then, would you? If you had that cash?
Yes, sir.
So you, despite that fact, went ahead and committed 3 new state jail thefts, less than a month or 2 after being put on probation. Yes, sir.
Yes, sir.
And isn't it also true that back in 2021 and 22, when you were being investigated for the thefts that you just pled, that you pled to back in December, that you cut your ankle monitor?
Yes, sir.
Why would you do that?
Because she was being traced.
Because I was afraid to come back to jail and I was just came home from jail.
The PSI reflects it, Judge. The detective informed her in her interview that she was being tracked with that ankle monitor, bond conditions from this court, and was connected, that it was connecting her to new offenses. And so the next week she cut her monitor.
And from probation, anything else from probation?
No, sir.
Y'all had a good relationship.
Yes, sir, we did. Miss Wells was very respectful. She didn't feel like that she would be able to find suitable employment, but I believed otherwise. I wanted to try. There were some places that we could try that didn't involve money and products,
Okay.
to be stolen. So, but
Okay. All right. So here's what the court is going to do. We're going to take up the probations first on 21-38407 and 22-39895, for which you were sentenced to 8 years in prison, probated for 10 years. The court has found that allegation number 1 is proven true in the motions to revoke probation. By preponderance of the evidence or greater, your probation or revoked, you were hereby sentenced to confinement for a term of 6 years imprisonment on each of those. In 22-39897, 40324, 40325, 40326, 40327, 40328, 40329, 40330, 40331, and 40332. Those are each state jail felonies. And for the state jail felonies, that those were just flat state jail felonies.
Yes, sir.
But those are not state jail felonies punished as a.
No, sir. They are state jails punished as state jails.
So in each of those cases, the court finds that the motions to revoke probation are granted by preponderance of the evidence or greater, as allegation 1 in each of those cases has been proven true, and your probations are revoked. You are hereby sentenced to confinement in the state jail for 18 months on each of those cases.
And Judge, we would ask too that the judgments reflect the restitution amounts that are listed on the front of the PSI in each of those cases.
And okay. In 22-39897, restitution is ordered to the complainant in the amount of $1,815. In 22-40324, restitution is entered in the amount of $1,485 to the complainant in 40325, restitution in the amount of $1,966.85 is ordered. To the complainant in 40326, $4,776.35 is restitution ordered in the judgment. In 40327, $1,695.20 to the complainant is ordered and rendered in the judgment. In 40328, $1,860 is ordered to the complainant, and that shall be rendered as well into the judgment. In 40329, restitution is in the amount of $1,417.15, and that is again to the complainant, rendered in the judgment. In 40330, $869.20 is rendered in the judgment to the complainant. In 40331, restitution in the amount of $7,055.45. That will be also reflected in the judgment to the complainant. And finally, 40332, $1,384.05 is the judgment to be rendered to the complainant. In 816, 817, and 818, the court has found the defendant guilty of these state jail felonies in each of these cases, as allegations 1 and 2 have been proven true by beyond a reasonable doubt, and that is enough to find the defendant guilty of the indictment in each of these cases. I so find in each of these cases. You are hereby sentenced to confinement in the state jail for a term of 2 years on each of these 3 cases, and you those terms of confinement are suspended. You were placed on probation for 5 years on those cases. In 817, restitution is ordered to the complainant in the amount of $2,748.47, and in 818, restitution is ordered in the amount of $309.73. Those 3 cases shall run consecutively in addition to the sentences in these other 12 cases. So you're going to be back on probation. Looks like you have 527 days credit. And since those are going to run concurrent, at least 527 on one felony, 417 on another.
Although that may.
No, that was, no, I'm sorry, 417 days on all 22 cases, and then 222 days credit on this.
Right.
So she may not be confined for long. The way I'm looking at it. But then you're going to be back on probation. And one thing you're going to have to do is pay something back, because this is the most prolific amount of thefts this court has ever dealt with at one time. And you don't want to be known in this county of 250,000 people to be the biggest thief. That's not, if you're worried about your children and the way they're perceived, you don't want their mother to be considered the biggest thief in the county. But that's the way it looks. These are all choices, and especially in light, this concerning situation is in light of the fact that thousands of dollars were in your possession, of cash, but none of that went to restitution. That is all.
Thank you.
Thank you, Judge.
Judge, I just had one other number
What's that?
on the screen. But I can tell you. Green. Did I say that out loud?
Did you have a criminal history here in Jefferson County, please? Ricky Sloan. All right. You are Ricky Bernard Sloan III, correct? Bugs are here. Get the spray. What happened to number 2?
It was refused,
What's 4?
refused by the DA.
What's 3?
Those are.
But number 4 was refused to? That's.
I'm about to look, Judge.
All right, you were charged in 23 CR 738 and also 739 with on or about May 1st, 2023 in Jefferson County, Texas. In 738, it is alleged you committed aggravated robbery. That is a first-degree felony, which carries with it no less than 5 nor more than 99 years confinement in prison or life imprisonment. And in 739, it is alleged you committed deadly conduct with the discharge of a firearm, a third-degree felony. So you would be facing no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 in that particular case. Do you understand what you're looking at in these 2 cases?
Yes, sir.
Okay. Hold on. The new improved computer system's having problems.
So. The case will appear the deadly conduct that was dismissed.
Yeah.
The complaining.
2 and 4. 2 and 4. Brandon.
Right, that's what I'm, so.
That was number 3. Thanks.
So in number 4. That case was dismissed. Let's see why. Complaining witness was deceased.
Okay, those are the only priors. Okay.
Right.
So where are we? What? What did you say something about bonds?
Yes.
What are you asking for?
As long as the court will accept.
What are the bonds?
On the aggravated robbery, it's $500,000. Now the deadly conduct is $250,000.
Okay. Go ahead. Anything else from mine?
No, Your Honor, just we would like to reduce down to.
Who doesn't?
Well, I think in this case, $500,000, $1,000 is excessive. And that's of course something lower than $100,000 each in each case.
How many people were shot here? Do you know?
2 defendants, the victim and there was a bullet that went through an apartment and almost hit somebody.
What's the but you got 2 different complainants.
Yes, sir. One was
says
inside of
shooting
it.
a firearm and knowingly discharging a firearm at the direction of another person.
One was the person being robbed. The other one was an innocent bystander in their apartment. The bullet went through into the apartment where they were at. Yeah.
How many times was the victim shot?
Twice. Make sure.
When the defendant had been shot, he was shot?
Yes. Both of the alleged victims were shots.
Oh, your client is a victim?
Both the alleged defendants, I'm sorry, Your Honor.
Well, I only have one defendant here.
There
Two different cases.
are two defendants part of this overall. I'm thinking of a discovery. Like Mr. Letter said, both of the alleged defendants involved in this case were shot at by the victim.
Has he been shot? Sanchez is our victim, has been shot in each knee. To both of his knees. And a right cheekbone on his face.
I don't understand where did this occur? Like, what was the environment? Was it a parking lot? Out on the street? Where?
It was a parking area.
This says the defendant here
Was that a
had
parking
an
complex?
AR-15 style rifle and the victim was robbed at gunpoint by two people, it looks like, right?
Yes, sir.
And the person with the AR-15 is, y'all saying this is the defendant in this case?
That's the allegation.
Sloan shot the victim. Where was the victim shot?
Shot in each knee and had a bullet wound on the cheekbone.
And then shot in the face and in the knee?
Yes, sir.
In the knees? The victim pulls out his gun and fires back in self-defense. Then several unknown suspects begin shooting at the vehicle that the victim was in. Somebody says, I've been hit from the other car, they're shooting. And sure enough, here's the defendant who's been shot in his left hand. He shows up, same as Elizabeth. And an AR-15 rifle was found in the apartment that the defendant went to. There's another night here in, was this in Beaumont, where everybody's just shooting the town up? Is that right? Was that in Beaumont?
Yes, sir. And there was an allegation that there was more than two. It was about 6 or 7 that were trying to rob him.
A gang, a gaggle?
A gaggle or whatever you want to call it.
All right, so what's they say?
I think the bonds are sufficient. This could have killed not only the victim, but also the person inside apartments and put a lot of people at risk in the apartment complex.
This is again, sounds like some of the cities that we're reading about where ruthless behavior and senseless terrorism is just out running amok. No, the streets are supposed to be safe. People are supposed to be able to walk around without people sticking AR-15s in their face and shooting them, literally in the face. This is based upon Article 1715 of the Code of Criminal Procedure, which details the way bonds should be assessed. These are a too aggravated set of circumstances, which this court finds or aggravating and do not lend itself to any mitigation. I mean, multiple people could have been shot here, but the thing is it's Beaumont, Texas. You're not supposed to be shooting them. You're supposed to be like studying for school or going to work or something like that. not trying to kill people and make the world a worse place in a city. As now we are, the most dangerous city now because of people like you. If this is to be believed, you have vaulted us into number one, and that's not anything that's proud. That puts a cloud of shame over this city where good, decent people are trying to do the right thing. But you're working against that. But there are a lot of people who are going to rise up and say enough is enough. And they tend to be on juries. So the bond is not reduced, and we're going to trial. Is that, if that's what y'all want?
We're not at that point, Your Honor. But I would like
When is your announcement date?
2 or 3 weeks.
You have 3 weeks. That is all. Who else, John? Is that it for yours?
I think that's all of mine, Your Honor.
Okay.
As far as I know.
We had Mr. McClung. Do we have is Gonzalo Alvarado still something we need to take up?
It is, Your Honor.